Acting as a personal representative. There's no limit to the number of people who can be appointed to act as executors in a will. That said, only 4 people can take out probate, so it's unusual for more than 4 to be appointed. Regardless of how many people are appointed as executors, not all of them need to act. It's often a good idea for just one person to act, as this makes it quicker to sign forms and other documents, which in turn reduces the total time it takes to deal with the estate. Executors who decide not to act have 2 options. They can have power reserved to them, or they can renounce their role as executors. See our video on role of a personal representative. Having power reserved simply means the executor isn't involved with the estate at this stage, but still has the option to take out probate in their own name at a later date. There are a number of things it's important to know about having power reserved. Firstly, it means an executor can take a back seat in dealing with the estate, but they don't give up their right to take out probate completely, which gives greater flexibility and peace of mind. Executors can step in at any time and apply for probate in their own name. For example, if the acting executor dies or is no longer mentally capable. Stepping in like this is quick and simple to arrange. All you need to do is send a notice to the non-acting executor saying that you're applying for probate. Unlike having power reserved, renouncing means an executor steps away from the role completely and has no involvement in the estate. There are a number of things it's useful to know about renouncing the role of executor. First of all, an executor can only renounce if they're not already dealing with the estate, a situation known as intermeddling. To be on the safe side, it's best for executors to make the decision to renounce as early as possible. Renunciation is final. Executors can't change their minds and become involved later. Because they aren't involved in the estate, an executor who has renounced isn't liable for anything to do with the administration. And lastly, the executor must renounce in writing and therefore must agree to give up their right to deal with the estate before the other executors can apply for probate. Important points. Problems can arise when someone wants to act as an executor, but the other executors, or even the beneficiaries, don't want them to. If this happens, it's important you get legal advice to avoid potentially costly litigation. If the deceased's will didn't name any executors, or they've all died or can't be found, then it's also important to get legal advice. Top tip. If someone chooses to renounce their position as an executor, it's important to check the will to see if it names someone else to act in their place.